So concurrent filing has existed in many other immigration categories before EB-5. And it was with the RIA that this possibility now became something that we could take advantage of in EB-5. So typically, what would happen historically was that a person would file a form called an I-526 form with the USCIS. That's a form that has information about the project you're investing into, as well as the money that you use to make that investment. Important part of EB-5, the US government doesn't want to grant an immigration benefit to somebody who earned their money unlawfully. So this is something that's heavily scrutinized. So anyway, the USCIS would adjudicate the I-526, and investors were unable to gain any immigration benefit from that filing until it was approved. And that could sometimes be 18, 24 months, maybe even longer. Once it was approved, then the individual had two choices. If they were outside the United States, they could do something we call consular processing. So they would go to their consulate, the US consulate or embassy, and essentially have an interview after having filed certain forms and undergoing medical examinations and so forth. And they get a visa that's put inside their passport, and that allows them to travel to the US. And when they come to the US, let's say they land at JFK, and they are admitted at the port of entry, that visa will be stamped. And at that moment in time, they then get their green card. Actually, they get their green card status. Later, the green card is mailed to them, or usually to us. We check it for accuracy. But the start date of that green card, it's the same date that the visa was stamped. So you can see it can take some time, both the adjudication of the I-526 and the consular processing, before they derive a benefit. An alternative pathway was if somebody was in the United States in valid non-immigrant status, perhaps like a student or an H-1B holder, and they had an approved I-526, they could at that point file something we call adjustment of status. That is adjusting one's non-immigrant status to immigrant status by filing three forms: an I-485 form, that's asking the government to adjust that status, an I-131 form, which grants an individual travel authorization, and an I-765 form, which grants the person work authorization. So you get work and travel authorization, those two benefits, while you're waiting for the 485 to be approved. Now, this is historically, right? What can we do now? Well, now the government permits you to file that adjustment of status along with the initial I-526 petition. You do not need to wait 18 months, 2 years, or longer in order to get a real tangible benefit almost immediately. So on the chart that's now on the screen, you can see that the I-485 filing is right there underneath the I-526 e-filing, showing that they can be filed together. And actually, along with the 485 filing, you're also filing the I-131 and the I-765. Those two rights, work and travel authorization, often were issued on the same card. We call it a combo card. Some people call it a green card light card because it looks like a green card and it acts like a green card. Work and travel are two of the primary rights that you get when you have a green card, and you're getting them here just upon filing before any petition is approved. That's a huge, huge benefit that the US government gives to those individuals who are lawfully present in the United States. So that, in a nutshell, is really what concurrent filing means. And it's why this is now a real immigration strategy for all sorts of people who might not have a good strategy going forward.
Yeah, I completely agree. I think it's such just a tremendous benefit, which is why I think it's worth kind of taking a little bit more of a deep dive into. Nicholai, what types of people would concurrent filing be most likely to be a massive benefit for them.
Well, you know, Pete, I was listening to the radio this morning driving into work, and I heard a story about Microsoft laying off 10,000 workers, and I thought, well, that's something. That's something I'm going to mention on our webinar today. Those kinds of people, right? I mean, and I have many, many clients like that, right? So as people are beginning to learn, particularly H-1B holders, that EB-5 is an option, they are really beginning to flock to us, because let's think about what the reality is of being in H-1B status. I mean, H-1B is great, but it has some limitations, right? So you're a student, you come to the US. Most people who come to the US actually come as students. There are millions of people in the US as F1 holders. Maybe the only larger number is people who are here as visitors in B status. But students are here, they complete their studies, they can stay for a little while after they finish their studies in something called OPT. But that is of limited duration, depending on what kind of degree they have, maybe 12 to 36 months. And then they have to leave, or they have to try to find another way of staying. And one common pathway is the H-1B visa. There are a couple of challenges with an H-1B, though. First, you have to find an employer that's willing to sponsor you. So some of the big tech companies and other companies are well-versed in filing H-1B visas. They have robust immigration programs like that. May not be that much of a problem, but if you're looking at a smaller employer, they may not want to bother with H-1B. They may just limit their search to, qualifying U.S. applicants. The other thing is that there's a numerical limit on H-1Bs. People in this call may have heard the phrase, the H-1B lottery. Well, why does that exist? It exists because there are only 65,000 H-1Bs available for bachelor degree applicants. If you have a master's degree, your chances are actually better because the pool is smaller in terms of applicants, but the numbers of visas is also small. There are 20,000 that are reserved for master's degree students. So it is a lottery, but let's say you win the lottery and you get your H-1B. I mean, that's great, right? But I'm sure many of the 10,000 Microsoft workers that were just laid off were H-1B holders. And so now what can they do? Well, they have a 60-day grace period in which to try to find another employer to stay in the US. That's not an easy task, right? So that's, I mean, an incredible, not only have you just lost your job, but if you have kids that are going to US schools, I mean, the real disruption to a person and a family's life, I mean, it's almost beyond words potentially. And, even if, let's say through this first round of layoffs, I mean, if you're still at Microsoft with an H-1B, you're kind of looking over your shoulder now, right? Like you have this existential threat that is going to follow you around. And I mean, that kind of stress, that's the worst kind of stress because you have no control over it. Yeah. And I don't think it's hyperbole to say that EB-5 is a silver bullet for that. I mean, if you are here now and you were laid off, you can file an I-526 petition, maybe not today, and we'll talk more about the process. It takes some time to get things together, but let's say that you're in a position, you've done your due diligence, you understand the process. We can file an I-526 petition before, and an adjustment of status petition before your status in H or even in F expires. And you have a status. You can stay legally in the US. Approximately 3 to 5 months later, the EAD and the advanced parole will be approved. And at that point, you can work for anyone. You don't have to keep working for the same employer. If you lose your job, it doesn't matter. I mean, you lose your job, that's a bad thing, but you can go and get employment from any US employer without having to seek any other immigrant status other than the one you have pursuant to the pending adjustment of status. So it really is an immigration strategy and kind of a fallback position that people now have that they didn't have even a year ago.
Mhm. Yeah, and I think that last part is tremendously important when you look at the potential for moving or transitioning from H-1B to EB-5 or even from an F-1. Is that right now? I mean, between the Microsoft news this morning, but Amazon laid off 18,000 employees, Meta laid off 10,000 employees, Twitter laid off 2/3 of its workforce. Lots and lots of H-1Bs are in that. So the tendency is to look at this negative portion and say, wow, like this is your insurance policy against that, which absolutely is the case. But this is also something that gives you optionality, right? So, I mean, if you are, working at Microsoft and you are an H-1B holder or working at someone who is sponsoring you, having an H-1B can limit your mobility a bit, in terms of the upward mobility of salary, of status, of your position within a company. Whereas with an EB-5, you're able to move freely in between different occupations, which is a huge benefit for people moving forward with their career. And we get a lot of that as well from the flexibility that comes from a student who's on their OPT or is saying, and they're looking at what their career options will be. Those career options are a lot more robust when you have the flexibility to have that green card status.
Unquestionably. And that's not just for employers. If you want to be an entrepreneur and do your own thing, let's say you've been working at Microsoft and now you want to go and work on your own project, you can also do that legally by way of concurrent filing. So I agree with you. It opens up a whole host of different options that were previously not available, and takes away that existential angst. I mean, even if you're secure in your job, you say, I love my job. I like my manager. I've had my age. Maybe the company has said that they're going to file an I-140 for you and a perm, and you have a path potentially to a green card at some point. But if you're not there yet and you're still waiting for that, maybe you're retrogressed, maybe you're an Indian in an EB2 category or something like that, you're still going to be waiting for a long time, and you're always going to have that existential angst of the potential termination of the project or the employment. And EB-5 takes that away. Concurrent filing takes that away.
Awesome. So Nicholai, so we talked about concurrent filing and what a huge benefit is. We talked about those set-asides and what a huge advantage those are, and what a huge part of the new RIA that is. Let's tie those together. How do those two different factors of the legislation combine to really make the EB-5 a real viable and potentially excellent option for people who are looking to move forward?
Yeah, that's a great question, because there is important interplay between those things. So in order to concurrently file, two things have to be true. First, you have to be lawfully admitted in the United States and valid non-immigrant status. So the outside parameters of that is the 60-day grace periods that you have under H-1B and under an F. But as long as you are in non-immigrant status, you can file an adjustment of status petition, but also only if there is a visa immediately available. And that is why these set-asides are so important, because right now, all three of those set-asides are what we call current. For those of you not familiar with the Visa Bulletin, I would invite you to Google Visa Bulletin, Department of State, and you can look at it and you can see how the State Department manages the waiting line for various categories that are retrogressed. They do it by way of something called a priority date. But if visas are available, they just put a big C for current in the chart. And if you go look at EB-5, you'll see that it's the EB-5, what we now call the unreserved category for Indian nationals and Chinese nationals, has a date in it. And what that date means is that you cannot take the second step in the process until that date becomes current. But right now, if you're investing in a set-aside category, you can concurrently file. And the good thing is that we don't expect those categories to retrogress for some period of time, because there are what we call lagging indicators. So even if we had, let's say, 1,000 I-526 petitions filed tomorrow, those categories are going to remain current until there is actual visa demand. That is, until USCIS is telling the State Department, hey, I have an applicant and I need a visa. And that doesn't happen until the I-526 petition is approved. And we're likely looking at a time frame of 18 to 24, perhaps more months. We'll touch on processing times a little bit later, I believe, in the webinar. But the opportunity is there. Now, will it always be there? That's hard to say, right? It is difficult to make predictions about visa bulletin movement. Many efforts have been made by very smart and sophisticated computer programmers to try to predict what the visa bulletin is going to do every month. And they invariably get it wrong. It is very difficult. It takes into account many different factors. But what I can say is, the sooner you file an I-526 petition, the sooner you will get a green card. That is a true fact, because your priority date is the date that you file your I-526 petition, right? When you go into the baker's office and you pull a number off the wall, that's the equivalent. You file your I-526 petition, that's your number. It's the lowest number, means you're going to get served first. Same thing with the I-526. You file it soon, you've got the lowest number, you're going to get your green card first. Now, let's say that you file, and let's say that you are from India or China, and you file in one of the high unemployment set aside. And when you file, it's current, and so you get your 485 filed, it's pending. The 485 can't be approved until the 526 is approved. And then you get the very important work and travel authorization. And then let's say like 6 months later, there's retrogression in that high unemployment category. Let's say for both Chinese and Indians. Well, what does that mean? It means that the 526 might be approved, but the 485 can't be approved. The 485 would remain pending. So then the next question is going to be, hey, well, then what about the benefits that I'm getting? Work and travel authorization. And that's the awesome thing. They don't go away. They could last presumably forever. You can continue to live and work, travel in the United States on your advanced parole and on your EAD card. Those are issued in 2-year increments. You can continue to renew them over and over and over and over again until your priority date becomes current. So the takeaway here is, I believe we're going to see significant numbers of filers for the reasons that we've just talked about, the layoffs and people taking advantage of concurrent filing. And that at some point in time, we may see retrogression in these set-aside categories. But the sooner you get your number and the sooner you get in that line, as long as you get those benefits before retrogression sets in, you've achieved something that's really going to help you professionally. It's going to help your family for the reasons that we discussed. You're going to be safe and be able to live and work in the U.S.